Honorable judges, dignitaries, ladies and gentlemen. I have the small role of talking about the role of Pakistani practitioners in international construction contracts. Only a brief overview would be possible. So let's see if I have this. There you go. So I'm going to talk a little bit about what the agenda would be very quickly. There you go. So we'll start with what international construction contracts are in Pakistan, the main areas of disputes, the standard forms of contracts, the 2017 FIDIC conditions. We'll talk about the dispute resolution mechanisms found in international construction contracts, what the law says and what the reality is, the role of the Pakistani practitioners, cultural and legal aspects. The way forward, we've got the arbitration bill of 2024. I have applied my mind to it somewhat, but I'm greatly benefited by the scholarship of Justice Miagul of Thursday evening. So I'll be talking a little bit about how that compares to the 1940 Act and how we are probably fortunate if this can be enacted into law. I'll also talk a little bit about the FIDIC conditions of 2017 and how we need to really fast adopt those. So what is an international construction contract in Pakistan? It has to have international elements, international parties, directly or through a local subsidiary, international forums, a court or arbitration, perhaps the choice of law and the provisions of a different country, although that's a bit contentious. International construction contracts in Pakistan. Large international construction contracts in Pakistan involving especially Chinese contractors and construction firms. Some of them I've listed. There's one of them, the dredging and reclamation at Pakistan Deepwater Container Port, Karachi Port Trust contract that I was a part of as a lawyer as well. Moving quickly to the main areas of construction disputes. Well, not surprisingly, payment delays. Payment delays are 10% of the disputes. Extension of time is 10% of the disputes. Behavior and competency of people happens to be 9%. And this pie chart pretty much covers the remaining areas of dispute. International construction contracts in Pakistan, the standard forms of contracts. Unfortunately, although we've made progress, there is almost no instance of the 2017 FIDIC conditions being incorporated. 34% of contracts are using the FIDIC conditions of the 20th century. 22% are still using the 1987 FIDIC conditions. So we definitely need to move on to the 2017 FIDIC conditions. The important features of which are the provision of dispute avoidance and adjudication boards, the DAAB. What used to be the DAB has now added avoidance. Emphasis on preemptively resolving disputes. Advance warning provisions. Parties are required to inform each other of potential future events impacting the project. It's much like a relationship, like any relationship. If we keep each other informed, if we communicate, then potential future events and disputes can be avoided. Not adjudicated, but avoided. Extension of time. Contractors in the 2017 FIDIC conditions are no longer required to submit a separate extension of time for variations in the scope of projects and works. The reduction of the period of the amicable settlement to 28 days is another important feature of the 2017 FIDIC conditions. Non-compliance with the DAAB decision allows direct referral now to arbitration, bypassing the amicable settlement period. The role of the engineer expands in claims resolutions. Engineer can facilitate agreements between parties. Neutrality of the engineer has been particularly emphasized in this respect, and that's particularly a problem in Pakistan, the confidence in an impartial engineer. What is the dispute resolution mechanism in construction contracts in law? So there's a multi-tier ADR clauses in FIDIC contracts, the engineer's decision, the dispute adjudication board, this is pre-2017 conditions, the dispute avoidance and adjudication board, which is now in the 2017 conditions. There's negotiation, mediation, and then, of course, arbitration. General conditions are often amended through the particular conditions of the contract. And of course, local parties are free to modify those conditions. Of course, the more formal and more constant we are, the greater the confidence of the international investor. The dispute resolution mechanism in reality this did surprise me. So there is a study that says that only 7% are aware of dispute avoidance boards. There's something that needs to change, because prevention is better than cure. We've heard that all our lives. Primary focus remains on negotiation and relationship management. So 63% basically resolve their disputes through relationship management and joint contract reviews and negotiations. Dispute resolution mechanisms in reality, also surprisingly, that negotiation with other parties still constitute 50% of dispute resolutions in international construction contracts, a figure that did surprise me. I'll come very quickly because you're staring me down now, so I'll come to the role of the practitioner. I believe that a lawyer should welcome this ADR, this push towards ADR, and this progressive approach that especially the judiciary has taken. And I think it had to start from the judiciary. I mean, everyone would have to follow the lead taken by the superior judiciary of the country, and no less than the senior puisne judge of the Supreme Court of Pakistan in particular, Mr. Justice Mansoor Ali Shah. Progressive approaches would obviously mean adopting the 2017 FIDIC conditions, which include the provisions for dispute avoidance and adjudication boards, advance warning provisions, and DAAB decisions which are expressly binding on the engineer. So lawyers must advise their clients to adopt these provisions, the ADR clauses, the multi-tier system, the 2017 FIDIC conditions, and of course, the new Arbitration Act that I'll very quickly come to. The role of the Pakistani practitioner can be to serve as a co-arbitration counsel, serve as experts on Pakistani law, perform factual investigations, effect court-assisted gathering of evidence, witness testimony, obtain pre-arbitral interim relief from local courts, and legal. And so I think the biggest hurdle in the way of ADR comes from our cultural bias. But because of this huge push now towards ADR, I hope that this culture can evolve. Because there are 2.4 to 2.6 billion pending cases, and really the legal system is choked, and which is probably why we're taking this very, very seriously. Now, coming to the progress, the new arbitration bill of 2024 is a pro-arbitration, has many pro-arbitration provisions. It has less room for judicial intervention, narrowly defined grounds for challenging an award. The Pakistan Engineering Council has happily now incorporated in the standard bidding documents of December 2023 the 2017 FIDIC Red Book, which will be notified and effective as of the 1st of April of 2024, which is good news. And of course, Pakistan is gearing up to sign the Singapore Convention on Mediation, the framework for enforcement of international settlement agreements. Coming very quickly just to,
please conclude.
Okay, well, it's a good thing that Justice Miagul has already educated us on the Arbitration Act and Arbitration Act of 1940. It's the judicial intervention that has been done away with. It's the decree, it's how the arbitration award automatically becomes a decree, and so on. So I'll have to stop here, but certainly there is promise now because of this push towards ADR, because of the Act, the FIDIC contract, the FIDIC conditions of 2017, and the culture that I feel is definitely now evolving. Thank you.
Thank you very much, Mr. Waheed.